Thank you very much, Sumto. Once again, my name is Chris Genevieve. I'm a PhD candidate at Monash University in Melbourne. And I'm presenting this paper jointly with my friend and PhD colleague, Johannes. And our paper is on the emerging role of African sub-regional courts in protecting human rights on the internet. I will deal with a part of the presentation discussing the role of the ECOWAS court in protecting human rights on the internet, and then Johannes will deal with the East African Community Court. Now, so my presentation will be short and would be around three main points. So first, I'll look at the layers of human rights protection in Africa. Then I'll focus on the role of the ECOWAS court specifically in protecting access to the internet and human rights online. And then I'll conclude by making a few remarks about why human rights protection, particularly in respect of protection of access to the internet and human rights online, is crucial to regional integration. So just a few words about the layers of human rights protection in Africa. So in my view, there are three layers of human rights protection. So traditionally, we've had the regional human rights system, which is based on the African Charter and its institutions being the African Commission, and later on the court, which now complements the protective mandate of the Commission. And then we had the domestic, at the domestic level, states still retaining the mandate to protect human rights domestically. And then if there were any, if local remedies are exhausted, then individuals could go to the Commission or the court. Now, in recent years, we've had a third layer, if you like, added to these two levels of protection, regional and domestic. So at a sub-regional level, you have some sub-regional economic communities that are also now engaged in protection of human rights. So typically, a lot of the sub-regional economic communities in Africa would have, as part of their core objectives, the protection and promotion of human rights. And then a few of them, like ECOWAS and the EAC, have gone a step further to create certain mechanisms for the protection of human rights, which basically involve adjudication of human rights claims. Now, so the ECOWAS court's mandate to adjudicate claims is specifically granted to it by the 2005 supplementary protocol, which granted the ECOWAS court jurisdiction to hear claims of human rights violations. The EAC's mandate, on the other hand, is as a result of the expansive interpretation of its mandate based on its instrument. So this is how basically these sub-regional institutions have obtained their human rights mandates. They were originally not established to be in the human rights business, if you like, but they have sort of been repurposed now to deal with human rights violations. I'll come later on to why I think this is important to furthering the objectives of human rights, furthering the objectives of regional integration. But to go on straight into the discussion on the ECOWAS court protection of internet access and human rights online, I think that is important. And the ECOWAS court has been very active in trying to push back on restrictions on the internet. So there are 4 cases so far that a court has been involved in, and each of them has profound implications for the enjoyment of rights on the internet and internet access generally. So the first one, I think the most important one, is Amnesty International versus Togo, in which the court held that the Togolese government shutdown of the internet in 2017 when some protests broke out in the country calling for amendment to the constitution to impose term limits, was a violation of Article 9 of the African Charter, which guarantees freedom of expression, and also Article 19 of the ICCPR. Then there is a case of Incorporated Trustees of Law and Rights Awareness Initiatives versus Nigeria, in which the court held that Section 24 of Nigeria's 2015 Cyber Crimes Act, which imposed hefty criminal sanctions for speech communicated via computer networks, which are considered to be grossly indecent or insulting or annoying, was disproportionate, that those sanctions were disproportionate and not necessary for limiting the right to freedom of expression, including on the internet. Then we have a third case of Festus Uguche versus Nigeria, in which the court agreed with the applicants that the Nigerian government's directive that they would have a prior vetting of programs that were going to be broadcast on either traditional media or streamed live online was also a violation of the right to freedom of expression. And then finally, you have SERP and Nigeria, which is the case concerning Nigeria's ban of Twitter in the country. So we all know the famous instance where the government of Nigeria banned Twitter. Now, so this case is dealing with that. The court is yet to give its final judgment, but the court has given a ruling on a preliminary objection that was made by Nigeria. In that case, Nigeria argued that the court did not have jurisdiction to deal with the case because the mere ban of Twitter did not implicate any human rights. Now, the court overruled that, citing its previous decision in Amnesty International versus Togo, where it held that although access to the internet in and of itself is not a fundamental human right, because access to the internet facilitates the enjoyment of certain rights like freedom of expression, you could consider access to the internet as a derivative right or a component of the right to freedom of expression. So based on that decision, the court held that denial of access to the internet or services provided on the internet could implicate the right to freedom of expression. So it was a human rights issue. And so the court held that it has jurisdiction to deal with the case. So the court is still hearing that case, and I think they'll probably give judgment maybe later this week or next week. Now, so these are the 4 cases that deal with access to the internet and also the exercise of rights on the internet. Now, my final point will be on why I think the role of sub-regional courts in this area is important. So the sub-regional organizations in Africa are mainly economic organizations, primarily. And if you look at the Abuja Treaty, which lays down the roadmap for the implementation of the African Economic Community, those RECs or regional economic communities are supposed to be the building blocks of the African economic community. However, when you look closely, you realize that there is a close connection between regional integration or sub-regional integration and the protection of human rights. This is because the ultimate objective of any integration agenda is to promote the socioeconomic well-being of the peoples of the integrating states. So even where you do not have the human rights promotion or protection, especially indicated in the instrument setting up a regional integration institution, I think implicitly you can say that the objective to promote human rights or protect human rights or realize some form of human rights, at least socioeconomic rights, is sort of like implied in the very essence of integration. Now, also, you would agree that if there is, let's say, gross violation of human rights that could lead to instability in any of the integrating states, that could destabilize the whole region and by extension, the integration agenda. So to that extent, I think there is some interconnectedness between human rights and integration. So they are mutually reinforcing. Now, so when you look at the right of access to the internet generally, and also specifically the enjoyment of rights on the internet, I think that's crucial to any integration agenda. Now, we live in an age where the world is connected by the internet. We are all, joined here together from various countries across Africa, some of us in the Asia Pacific, others in Europe, etc. So the internet, I think, has been one of the single most important tools that has helped in globalization. And given the importance of the internet also in things like e-commerce, education, political meetings, etc., and generally social interactions, it is crucial. It's an important tool for integration. So I think that the role of sub-regional courts, especially in this case, ECOWAS, the ECOWAS court, in upholding access to the internet and enjoyment of rights in the internet is not something that we could say is sort of a deviation from its mandate. I think it's actually an integral part of it and essential for promoting the integration agenda in ECOWAS and by extension in Africa. I'll leave my list. I'll leave it here and let Johannes continue with the discussion of the EAC. Thank you.
Thank you, Chris. You already touched most of the points that we have. So I start with sources of law, and I go ahead briefly with jurisprudence of EAC, and then finally I will conclude with challenges of enforcement. So to begin with, these sub-regional courts in Africa, as in terms of source of law, they are applying basic instruments that funnel through the African Union as well as the African Commission. So, for example, recently these courts used heavily on the resolution and the declaration of the African Commission. In relation to access to the internet, for example, the African Commission made a landmark resolution since 2016, following a lead from the UN Human Rights Council, which made a resolution that made access to the internet as a human right in 2012 by declaring that the same rights people have offline must be protected online. That declaration has been adopted by the African Commission in its landmark resolution in 2016. And then the Commission went beyond that and made a comprehensive declaration of principles on access to information and freedom of expression in Africa. And in 2019, especially if you look at Principle 5 of the declaration, it made it clear that people in Africa can enjoy human rights both offline and online. So this can be theorized as, as a normative equivalency paradigm. Recently, Yuval Shani and Daphne Dror wrote an interesting article at European Journal of International Law, and they argue that to enjoy digital human rights, we need to apply this normative equivalency paradigm in the absence of express, mentioning of these human rights as a human right. So this is important. And also very recently in 2021, the African Commission made an interesting resolution 373 on the development of artificial intelligence, robotics, and other emerging technologies. And it noted that access to internet is important to enjoy these rights, and also a little bit to tame the activities and behavior of non-state actors like social media platforms, and also those search engines and other actors on the internet. Having said this, in terms of jurisprudence, the East African Court of Justice thus far made a few pronouncements on offline media freedom and freedom of expression. For example, in the case between Burundi Journalists Union versus the government of Burundi, the court said, like the Press Act of Burundi, which was made in 2013, violates the various provisions of the East African Economic Community Treaty, particularly Article 6 and 7 of the establishing treaty, because these generic treaty provisions help us understand the realization of human rights. So even though in this case, it's not directly related with access to the internet, it has a significance by creatively interpreting, through this normative equivalency paradigm. And also in 2018, in the case between Media Council of Tanzania versus Attorney General, 3 civil society organizations lodged a claim before the East African Court of Justice to challenge the various numerous sections of the Tanzania's Media Service Act, and the act on its own breaches Article 9 of the African Charter, as well as the various provisions of the East African Establishing Treaty, and then ordered the Tanzanian government to line up this law with the treaty establishing the East African Community. But to make it clear that the East African Court of Justice is very creative in terms of, repurposing the original jurisdiction, the original jurisdiction of the tribunal. So, for instance, it has generic clause on good governance under Article 6, and also it has generic clauses on rule of law, democracy, and human rights. All this could be applied. The realization of democracy will not be achieved without protecting human rights. So by creatively interpreting these provisions, the East African Court of Justice is now protecting human rights, especially on media freedom, freedom of expression. So we could extend this through this normative equivalency paradigm that I explained earlier. And having said that, when we assess in terms of the effectiveness of these sub-regional courts in Africa, basically ECOWAS as well as the East African Court of Justice, even in general, like the compliance rate in Africa, especially those international courts in Africa, seems to be very low. For instance, a recent report by the African Court on Human and People's Rights noted that the judgments of the African Court is now only complied 7% of its judgments. So this means like still judgments are not complied with. So when it comes to these sub-regional courts, even the situation seems to be a little bit concerning. And for instance, I see this report from the ECOWAS court recently when it celebrates its 20 years of establishment. Only 40% of the member states, among the member states, respects or started initiatives to enforce the judgments of the ECOWAS court. So these countries are 6 out of 15. So this shows us the enforcement rate is still low, and also the total compliance rate across ECOWAS court seems to be still 30%. So this again needs more engagement and more activism on this as well. Other than that, we found in our discussion that the enforcement and this compliance continues to be an Achilles heel for these courts to be effective. However, we could also, assess effectiveness beyond, compliance through qualitative ways, such as, for instance, creation of ripple effects throughout the continent, kind of norm development, and also kind of through regulating the behavior of states. For example, I remember when the judgment of ECOWAS court on Togo regarding internet shutdown was made back in 2020. I remember various civil societies beyond Togo were using such kind of activism and also such kind of judgment to kind of pressure their own government. So we conclude that this sub-regional courts in Africa can foster, human rights on the internet. Thank you.